Hello, everybody. I hope you have had a good day. Thank you very much for watching and for being here. Today, there was a status conference hearing on the Idaho 4 case. So I'm doing it a little bit different tonight. What I'm going to be doing is sharing my commentary first, kind of a laydown of everything that happened in the hearing today, a quick summary, some of my thoughts. Then I will play the whole hearing, and what I did was I zoomed in the hearing, cleaned it up, and then I boosted the audio. It was a little hard to hear. So anybody is welcome to use that portion for anything that you need. You're welcome to that if you want it, if you need it. Now, I did this for that reason, so that they would be separate, because some people like to just hear the updates and kind of the thought process and what's coming up and then just be done. And you can stop at that point if you would like. And some people want to see the whole hearing without commentary. So without people stopping and talking and stopping and talking. So I'm doing it a little bit different this time, kind of trying this out and seeing how this goes. So without further ado, here is my commentary and a rundown of what happened today. There were a couple of surprises. The judge came right out of the gate and said something. I was like, what? And then Mr. Bill Thompson said something later that was very offensive, in my opinion. So I'm going to go through all of that in this video. After this, I will play the hearing. So I will see you in 11 minutes. All right, so the judge came in, and his very first thing that he said was, I would say I'm happy to be here, but I'm not. Hold on, I think I got the quote wrong. I'd say I'm happy to be here, but I'm not going to start the hearing with untruths. That's what he said. I would say I'm happy to be here, but I'm not going to start the hearing with untruths. Wow. That wasn't the only wow moment for me, though. I will be going over what Bill Thompson said that really shook me. Couldn't believe he said it. But today, basically, this is kind of 2 wins for the defense, if you really want to call it a win. They got their change of venue that they wanted, and it looks like they're probably going to get a September 2025 trial date instead of June. And like I said, I'm not sure if those are wins, because this Judge HIPAA, is very experienced and very no nonsense, unlike Judge, in my opinion. So basically, the judge went over his expectations for trial, for motions, for the attorney's behavior, told them to get along, be adults, be professional, kind of went over all that. And then he said he was allowing Brian Koberger to appear today in his suit, in his street clothes. He'll address that issue again in the future for future hearings. So sometimes he'll say yes and sometimes he'll say no. It'll kind of depend on court security and what else they have going on. So it'll kind of be a toss-up. He said the stakes are as high as they can get in this trial. He then stated that the non-dissemination order will stay in place. He expects it to be religiously adhered to. Now, I thought that the victims were not included in the non-dissemination order, but the way that he read it, he said the word victims, And I thought maybe, is he correcting what he's saying in this sentence or not? Because he said it applies to all parties, victims, victims' attorneys. He said it like that. And I wasn't sure if he was saying victims as in victims' attorneys. You can go through this video and see if you think he meant the victims and victims' attorneys. It's kind of that really wasn't real clear, honestly. So first up was Mr. Bill Thompson. He said he's looking forward to the June 2025 date. And then Ann Taylor got up and said she's also looking forward to June 2025, but issues have come up, and she brought up 3 issues. She said that they have received a vast amount of discovery since August, 398 gigabytes of information received. She also said that one expert passed away, and then she went over that none of her team is under contract for what's going into effect on October 1st called the State Public Defense System. And so they're going to be needing funding changes. She said that they have 25 experts and investigators working on the case. I'm going to do a separate video maybe on the State Public Defense System and the changes that took place on that. But it's 12.2 rule for funding, and it sounds really interesting, but Idaho has big changes happening with the public defense spending as of October 1st. Now, as of October 1st, the state of public defense funding will apply. So it's kind of up in the air on what's going to happen there. So then the judge said, after she said all these things, her issues, the judge said that he was going to offer May 2025, an earlier trial date, but he says not now because of what Ann Taylor said. So for the timing, they kind of went over how long each is going to take. Mr. Thompson said they will take a month and a half to 2 months for their case. Then the defense said she will be taking 4 weeks for their case. If he is found guilty, they each said they would need 2 weeks to go through that process. Now, let's see. The judge then kind of asked them, what do you prefer, May or September? Bill chose May. Bill Thompson chose May, and AT, or Ann Taylor, I keep calling her AT, she chose September. Judge tried to get into a little bit about, what the role that expert who passed away was going to play. But Ann Taylor would not say anything due to the public setting. It was revealed that it was a mitigation expert. A lot of people in a chat that I was watching was like, oh my God, is Cy Ray okay? It's not him. It was a mitigation attorney. So now the judge asked if they're capable of meeting all of their deadlines and that were set previously by Judge. Ann Taylor said just flat no. She said she needs more time because of this expert who passed away. She was wanting a really long extension. She hasn't filed for one, the judge said, but he's looking at giving an extension anyway. They had an ex parte hearing after this hearing today to go over more information that they couldn't disclose to the public. And then he was going to be deciding right then or issue an order later on whether or not she was going to get a whole bunch more time. Her deadline on that was, I believe, January 6th, but she was asking for the end of April. So now there's still a motion related to the death penalty that the defense has been on. That is set for either November 2nd or the 7th, and now I can't remember. But that is still going to be held as scheduled. And then they got into a little bit more about the 398 gigabytes. The state, Ms. Jennings, got up and she said that most of it was previously sent to the defense in some other manner. It was already sent. Some of it in there is new. She didn't know which is new and which was already something that they already sent. And Taylor said she couldn't tell either. But, you know, I think that was kind of a, I don't know. I don't know if it was deliberate, but it doesn't matter because 398 gigabytes of data, they still have to go through it, every bit of it, to know for sure if it's new or not. Because let's say they got one body cam video from an officer that's, 13 minutes long, and they got another one that looks like it's the same one and it's 13 minutes long. They have to watch both of those. They have to watch everything and look at everything in there. So they kind of have to figure out what's new and what's not. That kind of sucks. Let's see. Now, when they were going over the timeline on the trial coming up, Bill Thompson said something that was really offensive to me. And I'm sure if the victims' families heard this or caught this, I was just like, did he really just, hello? He was talking about doing extension to September, and he was saying he was going to have to agree that he's really not going to be ready if they're given an extension on their expert replacement deadline and stuff like that. And then he actually said the words, I hate to say that, but it'd be like cutting my own throat in a sense. Sir, are you serious? You need to read the room. You are standing in a courtroom. I'm speechless. He really said that. What an awful analogy, Mr. Bill Thompson. He really said that. Now, it is marked in my video. You'll see that I have it marked, so you can go and listen for yourself. He really said that. But that is it. That's all that happened today. That's it. We wait for the next hearing. I think it is either the 7th or the 2nd of November. And that is it for tonight. After this, it goes straight into the hearing for today, the whole hearing. And again, all I did was zoom it in better and boost the audio for you guys. And again, anybody is free to use this section for whatever you might need it for. If you want to make it your own video or something. All right, so that was my commentary. Now I'm just going to play the entire hearing from today. It is 30 minutes long. So that's why I'm doing this live as a pre-recorded. It's just a little easier for me this late in the evening. All right, so let me get that shared over here. Here we go. All right.
All rise. District Court is now in session. Honorable Judge Hitler presiding.
Be seated. All right. Good afternoon. This is State v. Koberger. I want to go over the appearances this afternoon on behalf of the state. Would state attorneys please represent themselves for the record?
Thank you, Your Honor. My name is Bill Thompson. I'm the Lathrop County prosecutor. This is Ashley Jennings. She's my senior deputy. And then we have Mr. Nye and Ms. Beatty from the Attorney General's office. And then we have victim support staff with us.
All right. Thank you.
Yes, sir.
Defense?
Ann Taylor, attorney for Brian Koberger, Elisa Massa, and Jay Logston, counsel for Mr. Koberger as well.
Thank you. All right. like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some expectations of mine, given that I don't think any of you, other than Ms. Massoth, have appeared in front of me before. When you file memorandums of law, briefs, et cetera, please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from the staff here today. Today, I know there was an issue that was brought up with respect to Mr. Koberger's attire for today. I did issue an order yesterday permitting him to appear in civilian clothes for this hearing only. That is a matter in terms of future hearings that we will take up in a closed hearing the day of, but in advance of whatever our next hearing date will be. My intention will be that Mr. Koberger will not be present for that hearing because part of what we will be discussing are security measures. And I expect to hear from the transport deputies and the bailiffs regarding security issues that they want to address or that I have questions for them about so that I can make an appropriate ruling in terms of his appearance here, but weighing that not just against, of course, his rights, but also against the needs of security in this case. I do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics, not misstate the facts or the law to the court, and that when you cite arguments in your briefs, if there is contradictory precedent, I expect to see that. I appreciate in advance what should go without saying that I've just said in terms of your responsibilities. But again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to conform to the oaths that we've taken as members of the bar, as officers of this court. All right. I do have some matters with respect to scheduling that I want to go over today, but before I do that, I'd like to hear from you with respect to the matters that you either need to make me aware of or want to make me aware of. The other thing before I do that, though, I do know that Judge had entered a non-dissemination order. That still remains in place. And unless I, for some reason, remove that order, it will stay in place. And I expect it to be religiously adhered to by all parties, counsel, victims, counsel for the victims. And I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality expected as it relates to those. Okay, that's my one and only lecture for you for the remainder of this case. With that, let me hear from you. We'll start with counsel for the state.
Your Honor, I don't know that we have specific questions we want to propose today. We're looking forward to hearing the scheduling. I think that's going to drive for us, particularly the distance involved, any questions that we may have. I appreciate what you've already mentioned to us, and we will certainly honor all of that. Thank you, sir.
Taylor?
Thank you, Your Honor. There are a few issues that I wanted to make the court aware of as the court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025 trial date that had been issued by Judge in the case. But in candor to the court, I need to let the court know some issues that have come up that we face that causes me concern. First, I think the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information. And I can tell the court that nobody on the team has read every bit of that yet. So there's a vast amount of discovery to continue to go through. And I wanted the court to be aware of that. The second thing is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able to refill that role to have a new expert to do the work that that expert was hired to do, but we are not progressed to the point that I'd hope to be through no fault of the new expert. The court should be aware of that as well. And last, as the court is very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case, I do not have a contract yet. Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the court should be aware. Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
Thank you. So I am hopeful that Mr. Fredrickson will ensure that the contract is available for you and your team next week. I have no control over that, of course, other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case. As to 12.2 funding, my understanding is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as what we refer to as the money judge. I've asked him to remain in that capacity at least through the transition to the state public defense system in next week on October 1. My understanding is, and perhaps I will come to find out something different, but that once it goes to that system 12.2 as it relates to public defense funded attorneys on contract seeking 12.2 funding, that's no longer a thing, that would come through the state public defense budget, essentially. I guess we'll find out if that becomes a problem down the road, but that's my understanding, because that whole system that 12.2 is based upon is coming to an end. So given your statement about the trial date, my proposal to move this case forward into May is probably not going to land well with you, but that's what I wanted to talk about, is the timing of the trial. I'm concerned with a trial as currently set for a number of reasons, but first I want to find out from you, as you sit here today, what that trial looks like in terms of the number of weeks of trial, starting from after a jury is selected through the end of the evidence and before any potential sentencing phase. So what are your estimates of that?
Your Honor, I think it would be a fair estimate based on what we know at this point to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that
Both-
knowing,
Both just, is that just your evidence or does that include defense evidence?
well, I was just getting ready to say, I say that understanding or acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know, we do not know what the defense has in mind for their case right now. So all I can speak to is what we anticipate for ourselves. But I would think the state's evidence in chief should be able to come in a month and a half or so.
Okay. Ms. Taylor?
Your Honor, we estimate 4 weeks for the defense portion of the trial case.
Of the guilt phase.
Yes, Your Honor.
So 10 weeks. In terms of if there is a penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
You're right. From the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase, and the additional evidence that would be brought in, unless there's something we learned from the defense about their experts, it is probably take no more than a week.
Taylor?
Your Honor, I would estimate 2 weeks for that part of any trial,
That's
for our evidence.
for your evidence.
Yes.
Okay. So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is having it set to run the entire course of the summer. I think we will find to be difficult on jurors in particular. Jurors who may have children who are out of school in terms of being able to spend time, go on vacations with them, et cetera. That's one concern. The second concern is with school that typically starts in mid to late August, and jurors or parents who may have kids going off to school, the timing of that through August. And that's my primary concern about that time frame. I had 2 proposals. One was to start the trial in the evidence portion of the trial the first week of May. And the other would be to start the evidence in early September. And I'd like your thoughts on those. I'm not saying I'm have or necessarily will vacate the June trial date, but I want to look at alternatives here because I am concerned about that spread that takes the entirety of the summer.
And we hear you, Your Honor. By way of history, the summer, we advocated for that in Latah County because the courthouse is right across from the high school and the summer would have the students gone. If we were looking at the other 2 choices, we would propose May.
Taylor?
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point, based on the 3 reasons that I gave the court before.
So I'm not going to worry about the public defense change because I think that will take care of itself. The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but May is not tomorrow. May is many months away. So the one that concerns me that you brought up is your expert. And I'm not asking you necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet. I know that that doesn't tell the court a whole lot more than what I said before, but I really feel that that would disclose too much for me to say more. I could do so on an ex parte basis or with Judge Monson, our resource judge, but not in a public setting.
I understand. Do you anticipate being able to fulfill your obligations for your current expert disclosure deadline that was set by Judge?
No, not with a lot of confidence. I think that the work is going to take longer than to meet that deadline. I think if we met that deadline, I would have additional information that I would want to be able to present. And maybe I would have been stopped from that with that deadline.
So I don't have a motion to extend that date, obviously, and with the changes that occurred, I understand why you didn't file one out of the box, but the deadline, I think, is January 6th, something like that, if I'm not mistaken, for experts on the defense side.
That's one of our deadlines, Your Honor, yes.
I guess does the state have anything to say in response?
Not knowing the details of the challenges Ms. Taylor and her team are facing, I don't really know how to respond further, Your Honor.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert. But with respect to the expert you had to replace, when do you think you could disclose consistent with the scheduling order?
Other than the expert that had to be replaced, Your Honor, there were two separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert.
Can you tell me if the one expert is a mitigation or a trial expert?
A mitigation expert, Your Honor.
And what do you think you need for that mitigation expert in terms of a deadline? Compared to that mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So I have a lot of questions, but I'm hesitant to ask you the questions because I'm sure you're not in a position to answer them currently, given the forum. So, but March is a long time from now.
Your Honor, the time passes very rapidly, and I appreciate the court not asking questions I can't answer. I think if I had an end of April deadline for that one witness, I think we could make that deadline.
So understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues. And I think that she did tell us that that person had passed away and they were working on a replacement. If we are looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that, I feel like I'm cutting my own throat in a sense, but that's realistic.
Well, I can do one of two things. I can set a separate hearing ex parte to explore this further, but I frankly don't know how far that's going to get me. I mean, I can set a date, and my experience tells me that date will be complied with regardless, right? Yeah, 24 hours in a day, but if you use enough of those hours, enough days in a row, you get it done if you have to. At the same time, I don't want to put unrealistic deadlines. And so I can do that. I can have an ex parte hearing, or we can go ahead and reserve September. I will throw it to you, Mr. Thompson, is what you want, what you would advocate for.
Could I have just a moment? Your Honor, we would trust the court to do the ex parte hearing, see what's there and make the best decision and tell us what the expectations are.
Well, do you want to do that later today or you want to do it tomorrow? You need more time? You want to come back next week?
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing's over if the court has time, or I can come back next week at the court's convenience.
I think we'll probably be finished in here by 3 if we were to do it immediately after. Are you comfortable with that? Does that give you enough time to get to the airport?
Yes, I believe it will, Your Honor.
All right. Well, we'll give that a shot. All right. If I move this one way or the other, I will adjust the various deadlines that are in here. I won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the next set of hearings that we have?
Those are now scheduled.
I believe that our briefs are due the 10th of next month with the hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those deadlines, Your Honor.
I'm sorry, you were saying, counsel.
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
I think the state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in judge's last order and other orders?
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize
How
that
much of the, would you say 300 gigabytes?
398 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information. I've not calculated how much of that was new. So I can only rely on Ms. Taylor's, what she's represented to the court on that.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
Not all of it, Judge.
Okay. All right. Well, I will talk when we're finished here with Ms. Taylor without the state present in a closed hearing. What else do we need to talk about today, or do you want to talk about today?
Nothing comes to mind right now, Judge. I know that there will be plenty of opportunity for other discussions. As far as your meeting with defense ex parte, do you want the state for any reason to stay around, or would you like us to get on the road back to Moscow?
Are you flying or driving?
Driving.
Okay. Well, why don't you hang around just in case we need to, if I'm able to make a decision based on that, I can inform you what that is at least.
Yes, sir. Thank you.
Anything further, other than your your motions regarding the death penalty? Do you have any outstanding motions and the motion as it relates to Mr. Koberger's attire?
Your Honor, there's no outstanding motions right now. I do anticipate filing several motions in the motion to compel deadline. As far as discovery goes, I anticipate there may be some follow-up motions. I, of course, will first try to speak with the prosecutor to resolve those.
Right. I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case. So just be aware of that. It'd probably be more along the usual, 14-day timeline with respect to motions. If there's a lot that needs to be done with respect to them, we can talk about that. But okay.
On that point, Your Honor, as you can see, they're a multifaceted team. And on motions, we try to assign them to specific attorneys. On various motions, would it be acceptable to the court for those attorneys who are not actively arguing the motions to be able to participate remotely? Or would you like us to be present? We're happy to do either.
I'm fine with that. I just prefer those that are going to be arguing to be here just because it makes it easier to have that dialogue. So
Okay, thank you.
the others, if they want to appear remotely, that's fine.
Thank you.
And same for defense as well, depending on what defense wants to do. Okay. All right. Then if there's nothing else this morning or this afternoon, I guess we will be adjourned and have a discussion in a few minutes. All right.
Thank you, Your Honor.
Back in a few minutes once the courtroom is cleared.
All rise.
All right. So I may upload that just as a separate video, the trial from today. Just that. That is it for today. Yeah, interesting hearing. Judge Hippler don't play, does he? Thank you so much for watching this. I appreciate you all very much. Have a lovely day, and I will see you next time. Thank you very much for being here. I will see you guys later.